Hello, everyone. Good afternoon. This is Attorney Odunlami coming to you live from New Jersey. How is everyone doing? Good afternoon. Thank you for joining me. I have a really great topic for you guys, and I cannot wait to share it with you. So if you join in, please let me know you're joining. If it's the first time, be sure to let me know. Let me know where you're joining in from. Hi, Roma Jane. How are you? Hi, Damalali. How are you? Hello. Okay, guys. How is everyone doing this Tuesday? So, we've had a lot of wins. This week is Tuesday, but really, I got a really great win. A client that we filed a VAWA petition for, and she had been through so much abuse, and we got the green card finally. So excited. And then we had another client that her VAWA had been denied when she filed it on her own or with somebody else. I'm not sure how, but she came to us, and her case had been denied. It was a VAWA denial, and we responded to I think it was annoyed. Or no, we appealed it. We filed an I-290B. We appealed it, and her VAWA was approved. And what that means for her, because her children are under the age of 21, it means that her children will also get their green cards because they're derivatives. So this is part of the joy of what we do. Her case got approved. Now her children have a pathway to getting their own green card without having to, worry about who is going to file for them or anything like that. So they have that. And so today's topic is going to be, we're talking about I-751 denials. So I'm going to start off with telling you what an I-751 form is, what it's meant to do, and then we'll talk about the reasons why your I-751 could be denied, and we'll talk about, then I'll take questions. So when you marry a U.S. citizen, and your green card is approved when your marriage is less than 2 years, right? What that means is at the time your green card is approved, your marriage is less than 2 years, you will get a temporary green card. It's a 2-year green card, right? You are supposed to, anytime within 90 days before the expiration of that green card, which is only good for 2 years, remember? And to remove the the conditions, a successful removal of the conditions will now give you your 10-year green card. Now, the mistake a lot of people make is that they think because they have a temporary green card, well, I already got a temporary green card. What's the big deal? Honestly, I got to tell you guys this. The removal of the conditions can be harder than getting the temporary green card, because USCIS is now, they feel that at this point, you have no excuses. See, when you file your petition, initially you're newly married, you may not have a lot of, bona fides, proof that it's a valid relationship, proof that it's a real marriage, it's a good faith marriage. You may not have that because you may not have received your social security number, so maybe you couldn't file taxes. Maybe you didn't have a job. Maybe you couldn't do a lot of commingling of finances, maybe. But when you get your temporary green card, those excuses cannot work. You have a social, you are able to work, you've lived with your spouse for an appreciable amount of time, so you guys should be able to show commingling of finances. You should be able to show that your lives are entwined. You should be able to show it's a bona fide relationship. And so for that reason, when you have an I-751 interview, USCIS really, they're looking to make sure that they made the decision correctly the first time. All right. So let's talk about how you can do this. So 90 days before the expiration, right around there, you need to start getting your stuff ready to file the removal of the conditions. Now remember, if you file it earlier than the 90 days, you will get denied. They're very strict about that, right? And if you file it later, when the green card has expired, you will have to explain why you're filing it late. And a good faith explanation is enough. They're not really, they don't really give you a hard time on it, on explaining why you didn't file it when you were supposed to. Give them a reasonable excuse, and that's typically okay. So when you file, when you seek to remove the conditions, typically you're supposed to do it jointly with your spouse. And you're supposed to jointly file a form called the Form I-751, right? And then you and your spouse will, when you file this I-751, again, you're going to submit proof showing that this was a real relationship. We married each other for love, to be together, for companionship. And this is not a fake green card marriage. Now, there's nothing that says that, one of the reasons for getting married at the time you get married is to get the green card. That's not against the law, as long as your main reason for marrying this person is real. It's good faith. It's you're marrying them because you love them, because you plan to have a life with them. And if getting a green card is is something else that you're like, oh, this is fantastic, then that's okay. Like, for instance, maybe some people would have planned to get married the following year, but they're like, you know what? We want to start a family right away, so that let's file right now, get married right now, so that by the time, we by next year, you would have gotten your papers. We can, we can begin to build together financially, and we can have our children early, something like that. That's fine, but the main reason has to be that you want to be with this person, you want to build a life with that person, and that's what USCIS looks at. On when you guys got married, were you marrying that person at that time? Was the relationship a real, genuine relationship? Was it your plan to have a life with this person together, right? So when you file the Form I-751, you have to include proof that it's a real relationship, that it's a real marriage, right? And the proof of that includes, financial commingling. You have joint bank accounts. You file your taxes together. If you have children together, you have a mortgage together. All that good stuff. Which I've talked a lot about bona fides. What you need to present to USCIS to show that it's a real, genuine marriage, right? You want to have, photographs that show your life. And when I say photographs that show what you guys are doing, I'm not talking about naked selfies. That's horrible. You guys don't do that. Some people think that if you send pictures of you and your spouse lying on a bed in a provocative position, that it tells USCIS, oh, this is for real. No. That's trying too hard, and it's very off-putting. It's just not. No, don't do that. And selfies don't have the same evidentiary value as much as you guys with, taking pictures with family, friends, co-workers, going on vacation, doing things, holding yourself out in the public to be a couple. So you file the I-751 jointly with your spouse. That's one way of doing it. And then they send you the extension letter, right? Now that extension letter is now 4 years. Before it was 12 months, then it was 18, then it was 24. Now it's 48 months. So you get the extension letter, and together your expired green card plus the extension letter, right, is equal to a valid green card. You're still a green card holder. Even if the card itself is expired. Now, if the extension letter doesn't cover the period that the green card is expired, for instance, maybe your green card, you got it like 6 years ago and you've been extending it, and the 48-month extension letter actually doesn't cover the present time, and you want to travel, you do need to get an, a stamp, I-551 stamp, right? Okay, and your expired green card and the extension letter always have to be together. You always want to present them to show that you're in active green card status. Now, I want to mention this because this is really important before I go into the waiver. This is really important because USCIS has been making a lot of this mistake a lot, and some people don't realize that it could really affect them in a negative way. So you're supposed to get a 2-year green card because your marriage at the time you were approved was 2 years or less. But USCIS sends you a 10-year green card in error. That's a mistake. So when you get it, you think to yourself, oh my goodness, this is a windfall. Thank goodness I have a 10-year green card. I was supposed to get a 2-year green card, but I got a 10-year green card. Woohoo. No, no, no. That was a mistake, and you have to bring that mistake to USCIS's attention because you could find yourself in deportation proceedings if you take this 10-year card, right? You don't remove the conditions that you're supposed to when you have a temporary green card. And then you typically, when you go for naturalization, maybe when your card is 5 years or maybe even 3 years, you go to naturalize and, they will deny that naturalization. And at that point, they will look to see that you have not removed the conditions on your green card, and they may actually put you in deportation proceedings. So if you get the wrong card, if you get a 10-year green card instead of a 2-year green card, you have to file the Form I-90 to tell them there was a mistake. If you get a green card and your name is not properly spelled or the information there is not accurate, you need to let them know that it is a mistake by filing the Form I-90, okay? The same Form I-90 is what you use to renew your green card when 10 years have passed, then you want to renew it. Now, there's a difference. So if your green card is a 10-year green card and you want to renew it, you use the Form I-90. If it's a 2-year green card, you use the Form I-751 to remove the conditions, okay? So, what if the marriage doesn't work out? What if? Well, you'll be glad to know this, that immigration does not want you to be in a bad marriage or in a relationship where it's not working out. So there are waivers that are available for you so that you can remove the conditions on your own without the assistance of your estranged spouse, right? So I have people come into my office all the time. Oh my goodness, my spouse wants to divorce me. What am I going to do? I have a temporary green card, and they're all panicked. Baker says he's enjoying the presentation. Well, I'm glad you are. And they're all panicked. Oh my goodness, what am I going to do? He's going to divorce me. She's going to divorce me. I have a temporary green card. No, it doesn't matter. You can get a divorce. Actually, it's better. The sooner you file that divorce, the better for you. And I'll tell you why. Because divorce is one of the waivers. Of course, you have to show that the marriage was a real marriage. It was a bona fide marriage. That's a term we use. It was a bona fide marriage. And then you can submit your divorce decree along with the Form I-751 and check off on the section that says you entered into the marriage, in good faith, but it didn't work out. Now, the reason I say that you might as well just get the divorce proceeding on is if it's time to file to remove the conditions, and you file for the divorce, and the divorce decree, you haven't gotten the divorce decree, USCIS will not accept it is pending. they will send you a request for evidence looking for the judgment of divorce. So if your relationship is not working out and you really don't want to be in that relationship, or your spouse doesn't want to be in that relationship, just go ahead and get the divorce, right? Just go ahead and get the divorce, right? And then remove the conditions on your own by showing that it was a real marriage, it was a bona fide marriage, and then present all the documents that you would, from the time you got your, typically would present everything from the beginning of the relationship. But USCIS at this point is really looking at from the time you got your green card till the, till the date you're filing your I-751, what evidence do you have? Now, another thing about this waiver is you don't have to wait for 2 years. If you get divorced after a year and 3 months, go ahead and put in your waiver because you've gotten a divorce. You don't have to wait for the green card to, for 90 days before the green card to expire if you're already divorced. All right. So we have another waiver. This is the waiver of abuse, abuse or extreme cruelty. This is a waiver that's similar to the VAWA, Violence Against Women's Act. But the difference is with VAWA, you don't have a green card, right? And with the I-751, you already have a green card. You're just trying to remove the conditions on the green card. So you have to show, again, that it was a real, genuine marriage, that it was entered into for legal reasons, the right reasons, not a sham marriage, not a fake marriage, right? And then you also have to show the abuse you suffered, which could be emotional abuse, it could be physical abuse, it could be financial abuse, it could be verbal abuse, it could be sexual abuse. I mean, I tell you, there's a lot. Abuse is a whole topic on its own, If you feel that you're being gaslighted by your spouse, being talked down at, being treated in a really horrible way, right? Then you should present that. Write your statement. Talk about what you went through. Put in the evidence to show what you went through, right? And you may be called for an interview, and you have to be ready to discuss all of the above. The genuine marriage, the abuse, So, so that's the second waiver, right? Now there's a third waiver. If unfortunately your spouse, your U.S. citizen spouse dies, right? And you cannot remove the conditions with the person, so you can do that. You can remove on your own based on a waiver of death of the U.S. citizen, right? All right. Again, you have to show it was a bona fide marriage. That doesn't go away. USCIS always wants to know that you got married for good faith reasons and not just to get a green card. And then the fourth waiver is extreme hardship. Now, this waiver does not require you to prove a bona fide marriage. It just requires you to prove that you will suffer extreme hardship if you were not allowed to stay in the United States, if you're not giving you, permanent green card. So what are the reasons that your green card could be denied? Well, if you don't have the evidence, if you don't provide evidence of a bona fide marriage, if you don't provide evidence of abuse, they could deny your temporary green card. They could refuse to give you a permanent green card, right? If you file too early, that's another reason. I think we talked about that. If you file too late, that's another reason. Another reason could be criminal activity. If you get involved in some criminal activity that could make you deportable, yeah, that's a problem. Yeah, you should talk to a lawyer for sure. Okay. So, if USCIS believes your marriage was fraudulent, they will deny you. Yeah. At least on the first 3 waivers. And definitely on the joint filing. Just because you're filing jointly with your spouse does not mean that they're going to accept that it's a genuine marriage. They're still going to go through the checks to make sure, you know. And like I said, they could call you for an interview, go over the questions that you and your spouse are supposed to be able to answer, to show that your relationship is legitimate. So now when you get denied, what are your options? You can refile, right? You can refile. That's what you can do. Now, of course, if you've been denied and you didn't have an attorney the first time, you definitely want to get an attorney the second time, right? And if you were denied the first time, you will be advised why you were denied. So that really gives you, allows you to work on, presenting a stronger case the second time. So I think that's pretty much it. I-751s. So we do a lot of I-751s, and I think the important thing for you to know is that there are different ways to get your green card that don't include having your spouse, remove the conditions jointly. All right. So I'm going to ask a couple of questions. Hi, James. Thank you. James says you're doing a good job. Thank you very much. So I'm going to answer a few questions because I only have like maybe less than 7 minutes. I thought I saw a couple of questions. Let's see. All right. Robin says, I am married to a U.S. citizen. We had 2 kids. I suffered abuse and we divorced. I got my 2 years green card before the divorce and filed VAWA afterwards. But VAWA is taking too long. I think you mean you filed a waiver, because if you got your temporary green card, then you should have been filing a waiver of the I-751, a waiver, right? That's what you probably mean. It is taking a long time, Robin, right? Because that's why they gave a 48-month extension. Can you believe it? 48-month extension. So I wasn't sure at that time whether to be happy or to be sad, because on one, I was happy because, you don't have to worry, because a lot of clients with towards the 24 months that we were getting then still had not gotten a response and they were getting anxious, right? And so I was happy that 48 months gave them time so that they were still in valid legal, green card status without having to worry, But then it takes a long time and people just want to move on one way or the other with their lives. And another thing you need to know is this. If you're waiting, you file the I-751 and you're waiting for a response, you can go ahead and file your naturalization if you have reached the required time. Like it could be 3 years or 5 years. If you haven't heard from them, you can go ahead and file your naturalization. And typically what happens is sometimes it helps move the case faster, and what would typically happen is either they'll do the I-751 removal interview and the naturalization on the same day, or you will get your I-751 interview, quicker, because they know that, naturalization typically doesn't take as long as it takes for you to get your, for the wait period for the I-751. So maybe something you could do, Robin, is if you qualify to naturalize time-wise, maybe you should look into that. That might help, okay? I hope that helps. Irene Ta says, how do I get you to handle my case? Irene, you can call my office, 973-993-1900, and somebody will schedule you for a paid consultation. Or you can go online, www.odunlamilaw.com, and register, schedule yourself, okay? Sometimes the dates are really far off on my website, so if it's something that's emergent, you should probably call the office and we'll see if we can squeeze you into something closer, okay? So Ola says, Olad, hi Ola. He says, if you have not been denied, but they keep giving you extension and it's been over 4 years, what should be done? can you proceed with citizenship since you've been legal for more than 5 years? That's exactly what I talked about just now. Ola, you should, if you qualify, you should go ahead and file for your naturalization. And, you know, hopefully that will move your case faster. It typically does, quite frankly. Let's see. So Akancha official says, so you mean extreme hardship is a waiver that one can use to get a green card? Well, extreme hardship, there's extreme hardship as a waiver to remove the conditions on your green card. You have to show extreme hardship, right? But there's also extreme hardship that is an evidentiary burden when you're filing a waiver such as the 601, the 601A, and a whole bunch, 212. There's a whole bunch of waivers out there that you need to get forgiveness to be able to qualify to get a green card. So even though I use the term extreme hardship, it's being used in different settings. Okay, Akanchawa official. Katrin Nell says, are you working also with asylum case from another state? Yes, we do. Call us 973-993-1900. Shipat 1627 says, what interview questions would they ask parents of a U.S. citizen? Well, typically for parents of a U.S. citizen, they will look to make sure that, you know, they're your parents, you know. They look at the birth certificate. They want to make sure that the person you're filing for is actually your parent. And they always look at criminal records, you know. They also look at inadmissibility issues. Those are all adjustment of status issues. If you're doing it by consular processing, they look at all of that, you know, inadmissibility issues, make sure they're really your parents. And what was the other third thing I mentioned? Criminal records, you know. Okay. All right. So, oh gosh, sorry guys, I gotta run. All right, I have more questions here that I really wanted to answer, but it's 2:59 and I have a 3 p.m. interview. So I will come back again. Until then, have a great day. All right, take care. Bye-bye.